This story demonstrates the importance of thinking through all of the requisite steps in a litigation matter to make out your client's claim or defense, not only for judgment at trial, but also to preserve it as best you can from attack on appeal. This claim arose in a town on Vancouver Island where the clients and the lawyer had lived and worked for many years. Both were well known around town. The clients had fallen on hard times and needed money. The specifics involved a piece of industrial real estate that the clients had purchased. The site was contaminated and required extensive remediation to make it suitable for its intended use. The clients retained our insured to recover the remediation costs from the former owner, whom the client said had contaminated the site. The claim went to trial. The defendant was unrepresented at trial and did a terrible job of defending itself, resulting in an award in which the plaintiffs got everything they were looking for. The client at this stage was, of course, very happy with the outcome. The defendant then retained counsel and appealed the judgment. The Court of Appeal was concerned about the evidentiary record at trial, specifically that the plaintiff hadn't proven the documents it relied on at trial, and that many of the facts on which the damages award was based had not been proven. The Court of Appeal was also quite critical of the lawyer's work at trial and the lawyer's handling of the evidence both before the trial and during. The court pointed out that many of the problems could have been prevented if the lawyer had made better use of the rules of court prior to trial. The court pointed out that regardless of the quality of the opposition, the lawyer still needed to prove the elements of the case and should not have taken such a relaxed approach just because there was not much of a defense being mounted. The Court of Appeal ordered a new trial. Unfortunately, the necessary evidence was no longer available. The client was partly to blame for this, but so was the lawyer for not securing the evidence in the first place and not preserving the evidence. At the end of the day, the claim was dismissed. The clients then blamed the lawyer for what was by now a real mess. We had some defenses, but it was difficult to overcome the Court of Appeal's unfavorable comments on the lawyer's performance. We held an informal mediation at the client's premises, and the lawyer formally apologized to the clients for his work. We were able to resolve the claim, and the lawyer gave up a significant amount of unpaid fees. This claim could have been prevented if the lawyer had taken more time to think through the legal steps required to properly make out the claim and to preserve the result from appeal.